Hi there and welcome. This is Ask a Lawyer, you bet, on CP24. John Scholes here. Momentarily, employment lawyer John Pincus will be on your screen answering all the questions. He does all the heavy lifting every week. You got to give him credit for that. We'll get to some viewer phone calls here. We'll get to possibly some emails. And we always have a main topic on the show. But first, let me give you the contact information to reach out to John and his team anytime. The phone call will be 1-855-821-5900. Back it up to the email address. That is ask@EmploymentLawyer.ca. So let's go. It's going to be 3 employment agreement aha moments. That is the main topic as we get to that in the second segment of the show, and we roll on from there. But we always get you warmed up with a case of the day, a week that was. That's how we set the table here each week. John, what do you got for us this week in that regard, pal? What's up?
It's good to be here, and I'm glad to be speaking about employment law because it's such an important issue. People always tell me the same thing. When you've lost your job or something's going on at work, nothing else really matters, right? Your whole life is turned upside down. You can feel hopeless, you can feel powerless, you feel alone, you're not with your coworkers anymore, and it's very hard to know what to do. And often though, that first phone call that I get, what people say to me is, I feel like a weight has been lifted off my shoulders. And that's really what makes it all worthwhile, because it can be a very difficult wilderness there when you have lost your job and no one is telling you what you're owed. So here's a perfect example. I spoke to someone who had been working for an automotive shop for about 20 years, and the shop gets sold. Asset purchase agreement gets sold to a new company, and the old employer says, don't worry, it's going to be business as usual. I'm going to give you 2 months notice. The new employer is going to take over. You're going to have the same job. You're going to have the same salary, the same pay. Everything is going to be the same, so don't worry at all. They said, all right, I don't care. This sounds fine. New employer comes in, and before he starts his first day with the new employer, he says, actually, you know what? We kind of have our own guy. We don't really need you here anymore. Or we don't need you here at all, right? So because he hadn't worked for them yet. And because of that, when the employee went to them and said, well, okay, what about a severance package? The answer that employee got is, well, no, there's no severance package because you're not an employee. So that's when this person came to me and said, this cannot be right. I cannot be owed no severance after 20 years. Is what this company's telling me really right? And I said, actually, it is. It is right. The new employer, the new company that came in was never your employer, and therefore they do not owe you a severance package. However, the old employer, the company that sold the business, is going to owe you about 2 years of your pay. And that's exactly what we're going to help this employee to do. So a perfect example of why it's so important to get in touch with an employment lawyer, because the law often can be counterintuitive. And this is a very significant entitlement this person's now going to be owed.
So the tip-off point, the tipping point is whether he had stepped foot first day for the new employer and then got let go. Now it's the new employer's job for the severance, but he never, ever worked for them. So the old employer's responsible, yeah?
Exactly. So what the law says is if you as a new employer take on a new employee in most circumstances, and again, this is not all circumstances,
sure,
but most of the time, if you start working for a new employer, then it's that new employer that owes you the severance. If you don't start working for that new employer, then it's the old employer who sold the business and effectively constructively dismissed you by doing so, who owes you the severance. But again, even that is not a hard and fast rule. There are certain circumstances where it is the new employer who owes you severance. So that's why it's so important to speak to an employment lawyer to help you wade through which of those categories you fall into, so you know who to pursue for severance.
Nuanced for sure. Let's roll on, John. Thank you very much for warming things up for us, pal. Let's get to our first viewer phone call for the day. Listen up.
Now, I'm an employer, small business. I'm an employee who's 62 years old, been with the company for 5 years, is not working out. It just seems like this particular employee is getting progressively worse and worse and making mistakes. I feel like I have no other choice but to terminate this employee, and I know it's going to cost me severance. What could I expect to pay for
Actually, a smart phone call to reach out first before they make a mistake, right?
Smart phone call and a smart approach, right? You know, a lot of times what clients ask me when they're in this situation, when they're on the employer side, understandably, you know, someone is repeatedly causing them issues. They say, well, how do we build a case to terminate this person? How do we, you know, do we issue warnings? Do we start, you know, building up a record so that we can rely on it and fire them for cause? And I always ask them the same question. I say, do you expect this person to get better? Do you expect that if you give them warnings, they might improve? And if the answer to that is no, then I say, well, then don't bother, because the law is going to see through that, and it's not going to do you any good. Let's talk about what you can do to actually mitigate your liability, and you do have options. So let's put up the pocket employment lawyer here and see what the damage is here, right? So you've got someone who's 62 years old in a technical position, only been there for 5 years, but because they are in the older age bracket, they're going to be in the higher severance entitlement here, right? You see 8 to 10 months. So that can be very daunting, but there are things that you can do to help mitigate that. So there are various ways that you can pay it. Sometimes you can pay it by working notice partially or fully. You can pay it by way of salary contingents. You can pay it by way of a lump sum. And you can help that person to find a new job. That's one of the best things that you can do as an employer to lower your liability. So don't do it on your own. Do it with the help of an employment lawyer, because we can help save money and come up with a solution that's actually going to be mutually beneficial to both sides.
We have lots more to go here, but we got to get into a short break, which we'll do, and return with our main topic, 3 employment agreement aha moments. That's what the call is this week. We'll get to that on the other side. Stay with us. Lots more Ask a Lawyer is coming right up.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
All right, welcome back. You're still with us. Great. Love it. Ask a Lawyer continues here on CP24. John Scholes, your host, and John Pincus, our employment lawyer this week. Reach out to John with any questions before you sign anything, especially. There's that phone number, 1-855-821-5900. Email ask@employmentlawyer.ca. Scan the QR code on the top right as well. It is the 3 employment agreements aha moments. We call them the aha moments because they may come as a surprise that we're actually telling you to do these certain things. Number 1 always comes off as a big one, John. You are better off not signing an agreement when you start. I will repeat that. Not signing an agreement when you start. Why?
It's always funny to me when clients come up to me and said, you know, I really didn't like this experience with this employer. And one of the worst things they did is they never even gave me an employment contract. And I said, you know what? They just did you the biggest favor they could have possibly done you, because 90% of the time, the employment contract is not going to be for your benefit. It is going to be for their benefit. If you don't have an employment contract, it means you still retain your employment rights. If an employer is drafting an employment contract, they're not going to be drafting it for you. They're going to have their own lawyer with their own rights and their own entitlements in mind. So what are they going to do? They're going to limit your ability to compete in some circumstances. Harder to do that in Ontario now, but still some circumstances, some roles, they can do that. They're going to give themselves all kinds of flexibility to change your job, to change your pay, to change your location, to change your commission plan. They're going to give themselves the right to do as much as they can, give themselves as much discretion during employment, and give you as little discretion as you can after employment. And most significantly, they're going to limit your severance entitlements. And if you have a contract that limits your severance entitlements, that's now an obstacle we now have to overcome. Whereas if you don't have that, then your full entitlements remain intact. And that's why it's always, almost always, I'll say, better to walk into a new employment without an employment agreement, without a written contract.
Handshake good, 10-page document, not so good, right?
Not so good, unless you've had a role in negotiating that. I mean, if you could negotiate your full severance entitlements, then you have the certainty of exactly what you're getting. But usually we call these contracts of adhesion, right? They're contracts that are basically presented to you. It's like an Apple agreement. They present it to you, they say, agree here. You don't have a chance to say, well, I don't like this, I don't like this. No, they say, this is our contract, sign it, take it or leave it.
Having said that, aha moment number 2 is this: your employer cannot force you to accept a new contract.
That's right. I mean, that goes against the very nature of a contract. A contract is supposed to be between 2 parties, offer and acceptance. If one side of that is saying, sign this agreement or else, that's not a contract, and that's not going to be valid. But you don't want to be caught into that, because sometimes they may just present this as, well, we're just giving this to you because we're updating our records. And if they try and say you have to sign this and you don't sign it, a lot of employees will come to me at that point and say, well, I'm worried if I don't sign it, they're going to fire me. And maybe they will, but consider this. If they're putting this contract in front of you, and that contract, as it often does, has a clause that limits your termination entitlements, perhaps in a way that it did not before, or in a way that they can rely upon that they may not have been able to rely upon before, what is that employer thinking? Well, they're contemplating that they may want to terminate your employment. So you have to ask yourself, if they're thinking about doing that in the near future anyway, is it better to get terminated now when you have your full entitlements, or a couple months later when you've just signed all that away? Often it's better to just say, no, thank you, I'm not going to sign it. Often you will have greater job security than anyone else, because you're going to be the one person that is going to be expensive to fire.
We are talking employment agreement aha moments. Number 3 for the show is this, John. Just because there's a termination clause in your contract doesn't mean it's enforceable necessarily.
That's right. Now, of course, in an ideal world, you haven't signed that contract in the first place. In an ideal world, you have not signed a contract that gives away your termination entitlements. But sometimes you don't have a choice, especially if it's a new job, you're not coming from another job, you haven't been employed, you need the job, this is the deal, sometimes you have to take it. And I don't fault people for doing that. People have always done that and they're always going to continue to do that. So when they come to me in that situation, that's when I look at that termination clause and I say, okay, is this termination clause legally compliant? And fortunately, most of the time it is not. And if it's not legally compliant, it does not exist for all intents and purposes. And that means that we can thankfully still preserve your full entitlements, still give you the financial security that you're going to need as is appropriate in the circumstances. But don't try and do that on your own. Don't try and use AI to try and figure it out. There is no substitute to going to an employment lawyer, having a human being look at this document and tell you whether that contract is going to hold up.
Like he says, always reach out to John for more information, but we got time for another phone call before we get into a break. Let's get to that, shall we?
I had an episode where I collapsed and I spent 6 weeks in hospital. The young fellows that I hired, I was asked by my employer to start training them up. He took over my position. I've been told several times that there were projects all over the province. I offered my services. My employer said, well, subsequently, I've not been allowed to come back to work.
So it's the employer saying you can, not his doctor. It sounds like the employer, yeah?
Right, and that being the case, this is going to be a human rights violation, and potentially, depending on what they offered, a wrongful dismissal, if they offered anything, right, which is not clear. So what employees have to know in this situation is an employer has what's called a duty to accommodate. And accommodation means they have to accommodate your restrictions, your inability to work, up to the point of undue hardship. And what is undue hardship? That doesn't mean that something's inconvenient, even if it costs them something. It has to be something really severe, like they have to change their whole business model to accommodate you. If that's the case, then we might be in a different situation, might be a different discussion. But if your employer is just saying, look, it's just not convenient for us, we don't want to have other people having to work, slightly different hours to accommodate you, that's going to be a violation of their duty to accommodate. And in that case, they're going to owe you human rights damages. And often what's even more significant, they're going to owe you your full severance.
It is break time, John, so we'll do that. We'll get into a short break here. When we return, we'll switch tracks and get into the disability end of the firm. John will wax philosophic on that as we get back into it. More Ask a Lawyer is just ahead here on CP24, so don't go anywhere.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
And welcome back. Ask a Lawyer on CP24. John Scholes here. John Pincus, our employment lawyer, who's on the panel today, of course. But we're going to switch gears a little bit. We like to dip our toe in the world of disability law, which is actually the other half of what the firm covers. A lot of interplay between the two. But the contact information, basically the same. The phone number is the same, 1-855-821-5900 for the email for this segment. It is ask@disabilityrights.ca. You can write that down and keep it and use it at your leisure as well. By the way, there's a zero fee for consultations when you're dealing with the disability side, so don't let that deter you. But we always get into it, John. And I just mentioned there is a lot of interplay between what you do and the disability lawyers. How are they handy to you on like a day-to-day or week-to-week basis?
Oh, they're absolutely indispensable. I mean, there's so often that I have an employee who has been terminated in the midst of a disability leave or been terminated while they are actually on long-term disability, and maybe that's about to get cut off or has recently been cut off, or often the termination is triggered by the disability provider, right? The disability provider will say, we think you can go back to work, and the employer will say, okay, come back to work. Meanwhile, the employee is sitting there saying, my doctors say that I can't go back to work, which is really what matters the most, typically. And in those situations, you're going to need protection for both your insurer and you're going to need protection against the employer who have each deprived you of your entitlements, and often those are the same entity. So it's all wound up in each other, and it's so important to have that coordinated, and that's why I work hand in hand with the lawyers on our disability side.
You got to need them, and you got them. We'll get to a quick listener, or at least a viewer audio question here, John, to continue on. Listen up. Here it comes.
I'm on long-term disability for a back injury from a pretty bad car accident. My insurer just told me they have surveillance footage of me carrying groceries, so they pretty much had somebody following me around taking video. Now they're saying I'm not totally disabled and might cut off my benefits. What are my rights?
There's that scary term nobody likes to hear, totally disabled.
Right, right. And a very unpleasant situation to be in, a very common tactic of the insurers, as my colleagues on the disability side like to say. You know, the key here is that totally disabled does not mean that you can't do anything, right? And what my colleagues on the disability side will always say is it just means that you can't do your job or another suitable one. So the fact that you might be able to do groceries or handle the basic day-to-day of your life does not determine the merits of your claim. Now, the insurance company will like to say that, but the insurance company doesn't have the final word. The law does. So that's why you need to speak with a disability lawyer who can deal directly with the insurer and challenge what the implications of that surveillance evidence, right? What does that really say about what you can do and what you can't do? Because, of course, that's not the whole story. It almost never is.
And it's your doctor who has the final say of how much leeway you're allowed in day-to-day life. Maybe going to get groceries is part of this woman's therapy, but the insurance company doesn't see it that way because they're surveilling her, which you shouldn't be scared of, by the way. They're going to find something with it because they paid for it, but it's all about your doctor, right?
Right, the medical evidence has primacy here.
Right.
So that's what the law cares about. What is the medical evidence? Not, oh, we saw this person handling groceries and therefore we're going to deny this huge disability claim. No, it's much more nuanced than that.
Another question for you here, pal. Number 2 for this segment. Why is it often easier to get compensation with a disability lawyer than by appealing directly to the insurance company after your LTD is cut off?
Well, it's not so much that it's easier as much as the disability lawyer will take the brunt of it for you, right? I mean, the insurance company, when a disability lawyer comes in, is going to fight tooth and nail to resist that claim, but the disability lawyer is trained to deal with that. And that's why they take the weight off your shoulders, which is what happens at the appeal, and they handle it for you. Think about this. An appeal is going to be handled internally. It's going to be handled by the very same people who denied the disability benefits in the first place. What kind of incentive are they going to have to handle that appeal in good faith, right? No, you need an independent body to adjudicate the claim, and that's why we have the law. The law is independent, the law is impartial, and the law will get to the right answer. And that's why our team is so effective at being able to help people wade through those kinds of disputes.
Don't be the hamster on the wheel. Just get a hold of John and the disability team for sure. We're going to go back into some employment law here momentarily. But first, we got to take a short break as we continue Ask a Lawyer on CP24. Stay with us.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Welcome back to Ask a Lawyer. We got a few minutes left to go here. First, I will give you the contact information anytime to reach out to Mr. John Pincus. There you go, 1-855-821-5900. Ask at EmploymentLawyer.ca with that QR code as well. Generally, we've been liking to wrap up the shows every week with a viewer phone call. So why break precedent? We'll do that again this week, John. So listen up. Here it comes, pal.
I was wooed by a competitor to join the company as a senior manager. After a year, they felt it wasn't working out and offered me 2 weeks' pay plus another 2 weeks if I accepted the offer within 5 days. Is that a good deal? I'm 48 and made $120,000 in my first year.
What say you, Johnny? What do you think?
Well, the short answer is no. I mean, I'd certainly like to know more about the nature of that, wooing, the nature of that recruitment. How long was this person employed at the previous place? Because that's going to have a major impact here. But even in the absence of that, right, even if you leave that aside for one moment, that is clearly not a good deal. And the employer is going to make you think that it is a good deal because it suits them. So let's put up the pocket employment lawyer and see how much this person is owed, right? So even though there's 1 year of service, even though that person only has 1 year of service, and even though they're relatively young, or at least what I'd like to think of as relatively young, right, 48 years old, they're still owed between 4 to 6 months of severance. And I would say if it can be established that that person is recruited, you're going to look at an entitlement at the higher end of that range because the law does take that into account when determining how much that person is owed, right? So you see here 4 weeks versus 4 to 6 months, you're talking about tens of thousands of dollars, right? You got 60,000 versus, less than 10 between the high end and what they're being offered. So this is why it's so important to speak an employment lawyer, because the employer is saying to you, well, we're so generous, we're offering to you, but if you don't act now, you're not going to get it, right? It's only 5 days and this offer goes away. Well, what I say to clients is the moment you decide, the moment you and I determine that severance offer is not good, that deadline goes out the window. So you do want to speak to an employment lawyer before the deadline. You do want to make your decision before the deadline, because maybe you're that 1 in 10 people who've been offered a good severance package and you do want to accept it before the deadline. But 9 out of 10 times, it's going to be something like this, right? Where that deadline is just total nonsense. You don't have to worry about it at all. It's standard. Every termination letter includes them, but it's not meaningful unless it's a good offer.
It's like that, act now or you don't get the free set of Ginsu knives. Call a week later, you're still going to get the Ginsu knives. Don't worry about it. It's a pressure tactic, right?
Right. Remember also that the employer has an interest in getting this deal done. They're not offering this to you out of the goodness of their heart most of the time. They're offering it to you because they want you to sign that release that's attached to it, because in the absence of that, they're on the hook, right? And the time that you have to pursue your entitlements at law is 2 years from the date you get your notice of termination, right? So you don't want to wait 2 years.
Right.
You don't want to wait anything close to that, but you also typically don't have to worry about that 5 or 7 day deadline.
We hope that gave you a little bit of relief, right? So you can carry on, just take it easy, give John a call and reach out for sure. That is about all the time we have for this week, but continue to reach out. As you know, that phone number again, 1-855-821-5900, ask at EmploymentLawyer.ca. And by the way, PocketEmploymentLawyer.ca, John used it twice on the show. You'll have easy and free access, anonymous access to the severance calculator. PocketEmploymentLawyer.ca, use it anytime. Thank you for watching, and we will catch you again next week right here on Ask a Lawyer on CP24.